We have launched.
Welcome, everybody. You're officially tuned in to Planet Green Trees, episode number 158. We're calling it The Victory in Paw Paw. Today, of course, is July 25th, 2013, and Planet Green Trees is where you're at. We have a call-in number I'd like you to engage with. It's 347-326-9626. Let us know what you're thinking, or if you want to get in the air and have your thoughts heard or commented upon. I'm your host, Michael Komorn. Besides me in the studio is Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
Welcome, Chad. And, of course, Jamie Lowell from the Third Coast Compassion Center.
Hello.
Jamie, of course, is the producer of the show. He's the individual responsible for getting all the timely and important guests on and putting the show themes together every week. And I want to thank Jamie for all his hard work. Also, I think calling in later, although he can't be in the studio with us tonight, unfortunately, is our good friend Rick Thompson. I want to give Rick a big apology also. I did not get him on the show last week. I know he's on hold, and I know that can be frustrating, and I just couldn't stop talking about the law, and I apologize, Rick. But moving on to the show now. We're calling the show The Victory in Paw Paw because Komorn Law is happy to report, especially in light of the recent negative Court of Appeals decisions, such as People v. Jones and People v. Carruthers, the victory in Paw Paw. Husband and wife, patient, caregiver, clients, each charged with the manufacture and the possession with intent to deliver and felony firearm, a mandatory 2 years in prison. All charges dismissed. And we were going to hear from these wrongly accused as they'll be joining us to share their experience with the community. And I'm going to be adding my commentary on what, if anything, can be learned from this awful experience that two very kind, sweet, compassionate people had to experience being dragged through the criminal justice system for things they never anticipated would ever happen. Additionally, jam-packed with outstanding guests, our thanks to our producer, Jamie. Of course, we've got Stacy Theus and Carrie Boiter. Carrie Boiter is a champion for the drug war prisoners and criminal justice reform. She was recently named Patient Advocate of the Year by Americans for Safe Access for her tireless dedication to an awareness campaign to free Chris Williams. Many of you recall Chris Williams had a mandatory minimum sentence of 90 years, recently reduced to just over 5 through an unprecedented post-trial settlement agreement triggered by much of the hard work by Carrie and helped by leveraging through social media. Also, Carrie is the president of the board of directors for the Cannabis Defense Coalition and a member of the Seattle HempFest core staff and co-founder of ASA in Washington. Additionally, calling in, we will have Carrie Boiter, who, of course, many people in the community may know. She has been an activist for a long time. She's a writer, promoter, and developer of the West Valley Normal and the CannaSense program, as well as Cannabis, which is being driven around.
And this is Stacy that you're talking about.
I apologize. That, of course, is Stacy. Yeah. Theus. And, of course, Stacy, I apologize, Stacy, which she's the driver of the Cannabis being driven around the country to help educate people about cannabis on the Cannabis Freedom Tour. In fact, I understand, Chad, she showed up at one of the Birmingham Library Compassion meetings.
Yes.
But we've got an exciting show. We're going to hear from two phenomenal activists. We're going to be talking about this tremendous victory. We're also going to have core reports from
downtown Birmingham.
Steve Green of the Michigan chapter for the Human Solutions. And, of course, ongoing contribution from Rick Thompson of the Compassion Chronicles. Jamie Lowell, Chad from the Birmingham Compassion Center. This show sponsored by your host, Komorn Law, 1-800-656-3557, the Michigan Medical Marijuana Association, MichiganMedicalMarijuana.org. I want to thank all the moderators, administrators, volunteering their time to keep a safe, comfortable environment for the community to learn. Shout out to our friend Kevin Spittler, the No-Hio and non-psychoactive cannabis champion, and also to our good friend, the rancher, down at the Marijuana Ranch, also known as the Cannabis Cultural Center. Call him, find out what kind of culture you can learn about, 313-422-5281. I do want to mention, before we go into my rant, a couple announcements. Last week, we were gone for about 10 days. I want to thank the producer for putting that together. It's our longest vacation yet in this tireless job of radio performance. But the last Monday we did a special episode of the case of People versus Earl Carruthers, and good friend of mine and champion for the cannabis community, John Targowski, called in, and we addressed many of the legal issues. And if you're interested or still have questions about that, you can listen to that past episode 157. I also did about a 9 or 10 page blog about it. There's also some video associated with that, as we do every week on YouTube. I wanted to also mention that the Michigan Medical Marijuana Association, many listeners may not know, they may not care, but we have been putting together what I'm going to describe as a very quality newsletter. It's been inconsistently going out every 6 to 8 weeks, but we're about to, maybe today, tomorrow, if it hasn't already gone out, sending it again. There's some new content, fresh content, some opinions, some ideas and encouragement and reporting on. And this is going to be a vehicle for us to get the message out, and other exciting announcements are going to be coming. So if you're interested, you can go to the MMA and sign up for the newsletter, and we will get you on the mailing list. Likewise, our contributor Rick Thompson produces every week the Compassion Chronicles, which produces daily tons and tons of cannabis reform and medical cannabis related content. And I encourage all of our listeners to go and check out Rick's guest commentators and participants. And I want to also encourage people to see something that they may not have seen as of late, probably not under the current Attorney General administration. At the Komorn Law blog, we excitedly this last week put up a video and reflecting a 2010 scene where the Michigan State Police returned the medical marijuana that they'd seized from our client during a traffic stop. The cannabis was returned after we obtained a dismissal of all charges and court order directing the arresting agency to return the medical marijuana to our client. We do offer this warning for those that are interested, and this can be found at the Komorn blog. The warning is, what you see on the video may cause intense feelings of pleasure, joy, and glee, maybe nostalgia for a period of time before our Attorney General had the opportunity to start his campaign or crusade on what can only be described as an obsession about Swiss cheese. So go enjoy that video and be aware and view with caution. All right, so we're going to go into the rant here. I got to talk about this case, and we're going to my guests are going to be calling in. My clients are going to be calling in to share some of their experience. But we're calling the show the Victory in Paw Paw, and I want to get to the rant here. This is a very interesting case on a lot of levels. I'm going to read you the first news report on it, which was deputies with the Van Buren County Sheriff's Office, narcotics unit, said they seized more than 100 plants, marijuana, and 2 guns after raiding a home in Waverly. It happened at around 11:15 a.m., they say. Investigators say a 30-year-old Paw Paw man and a 25-year-old Paw Paw woman were at the home when they arrived. Deputies discovered an illegal marijuana grow operation, they say, in the backyard of the residence, including a total of now 113 marijuana plants. They say that a loaded 45 caliber gun, handgun, and 20 gauge shotgun were also seized, along with scales, packaging materials, and approximately 2 pounds of finishing marijuana. $6,400 in cash. 2 vehicles were also taken, they allege, in this report. Of course, as we've seen so many times, and there's the old adage, don't believe everything you read. Likewise here. And I can tell you the number of cases that have been reported on arrests, releases to the paper, and the story, the way that it's twisted, is told by the police officers. Likewise, when I warn my clients, when we get the police reports, we look at them, don't think for one question that can be slanted is the right word to use. It maybe seem a little strong, but remember, police reports, fictional, and news reports like this are intended for a number of different reasons, but one of which is to justify the behavior of them making the arrest. So the couple at issue is a young couple. They're married. They don't mention that in here, and they have a very good relationship. They're both caregivers, and were taking care of a number of different patients registered, and they were patients themselves. The issue that seemingly brought the police's attention to them was that they had I want to get a time sequence here. It was in September of July 2012. So long before we were given the benefit of the new amendments to the Michigan Medical Marijuana, giving some direction of the of how an outdoor marijuana grow is supposed to look. But nevertheless, according to the police reports, the officers were tipped off by an anonymous person, although they don't mention who that is. And this is not an anonymous person; it is a witness of some kind, and they need to disclose that. But there are many, many legal issues in the case. But the facts, as they're told, involve one individual police officer reportedly driving in the street by the house and being able to look into the backyard where he sees a fence within a fence, what he describes as a growing of marijuana, outdoor grow. He describes it as having fencing, wooden 4x4 planks around it, and a plastic sheen or visqueen surrounding it. The officer maintains that from his position on the road, which had to be over 250, probably 200 yards, I'd say, that he was able to see from the drooping visqueen surroundings the top of a plant. Further, because of the lighting, this is the second time I've heard this, there was a outlining of the plants with the visqueen in the way that the sun reflected through the back light drop of the plants, and was able to identify the actual type of plants as being marijuana. With that information, he went and got a fellow
like
officer.
the Batman signal to a police officer.
Yes. And with that information, he went and got another police officer buddy of his, and they came back the second day, and this time they'd fixed, so it says in the police report and through some of his testimony, the visqueen, so he couldn't see it from where it was, and despite the fact that one of the officers testified that still the outline of the plants could be seen in this light, the other officer testified that they could not. Anyways, the story goes that based on these observations, and they got a search warrant based on allegations in an affidavit that a magistrate signed, and they executed a search warrant the next day. Within the police reports, interestingly, is the statements by the police that they were not able to contact the owners of the property because there was a enclosed locked fence that guarded the property and did not allow them entry. The affidavit also suggested that the failure to have a roof on the property was a basis for that officer to conclude on what he knew, that an outdoor grow without a roof was a violation of the Michigan Medical Marijuana Act. So the shock and horror that a family goes through when this happened cannot be understated. And I've heard it from these people that never thought they'd have any interactions or any kind of piling on invasive police tactics, military type tactics, raid tactics in their home. And the experience can't really be removed from a memory. It's an awful story, but nevertheless, a lot of legal issues happened in this case. The first one was there was this issue of the outdoor grow, the execution of the search warrant, and the probable cause by which they got in there. And there was issues of whether or not they would be able to establish even probable cause that a crime had been committed. The issues, of course, which made it very, very challenging was that, like is happening across the state of Michigan, individuals who are law-abiding citizens, believing that they're in compliance with the law, are going to possess vehicles, they're going to possess potentially cash, they're going to have jobs, they're going to have things in their house, they're going to possess weapons, they're going to have permits for weapons, and they may be growing marijuana. And what's happening is the culmination of those things is causing major problems by way of the police and the charges and the connections and allegations of a crime, which make the possession of the weapon that's in close proximity to the alleged possession or growing of marijuana plants to be the use of a firearm in the commission of a felony. This is what makes cases like this outrageously challenging, because when it's a marijuana case, there's different liabilities than when there's a marijuana case with a felony firearm attached to it. When the felony firearm is attached to it, the worst case scenario that you can't avoid, and the court has no discretion at sentencing, is if there's a conviction for a felony firearm, it is a mandatory 2 years in prison, and no one can do anything about it. So a conviction at trial means you're going to prison for 2 years, and the judge cannot and will not, in any instance, divert from that sentence. So prosecutors do this knowing that it is leverage, and what would be a less of a penalty, less of a risk, less liability marijuana case is intensified to the highest extreme, where now an individual who never thought they'd be involved in the criminal justice system is now involved and is looking at not county time, which is bad enough on its own, but now prison time in the Michigan State Correctional Facility, also known as Jackson, Michigan, and other parts of its out branches. Anyways, so a lot of issues. I'm going to run through some because there's some interesting findings, and I don't want to go on too much. We've got packed house. We want to get to some other important factors, but I want to give a shout out first of all to Dr. Robert Townsend, because he was the doctor for my clients. He's done the certification, been their treating physician for a period, and I want to mention and take a second to thank him not only for his involvement and his willingness to participate, which has been such a difference from many of the physicians that I've been working with. And I say cooperative, I mean that he was responsive immediately, knew what to do, knew how to do it, interacted with my office with ease, was open to discussions with the lawyer, and knew that he had some responsibility, and knew more than just some responsibility, but took the responsibility to make sure that his certified patient had the support of the physician. Now, I say that and acknowledge that because of his phenomenal work in this case, and as he's done throughout the years of the Michigan Medical Marijuana Act. But I say it because it was such a difference compared to what we've had to deal with in some of these other cases. We have no cooperation, no charts, no file, no responsiveness. Can't even find them. And when I do get through to them, it's hatred to the lawyer. Why am I bothering them? Why can't you get this? What's wrong with you, lawyer, that you need to call me? So says the doctor. Anyways, one of the things that came up was that my clients, both medical marijuana patients, were ordered that they couldn't use their medical cannabis while on bond, and Dr. Robert Townsend assisted in providing the documentation necessary to really file what I would describe as a compelling case to use cannabis while on bond. This is the ruling of the district court judge. The defendants brought a motion for an order allowing each defendant to use physician-recommended medical marijuana while on bond. Hearing was held. This court has now had the opportunity to review the pertinent parts of the cases cited by the defendant, and in addition, the court reviewed the MMA and the pretrial release rules. Each defendant is charged with the 3 counts: delivery of marijuana plants, 20 to 200, 7-year felony, manufacturing of the same 7-year felony in the felony firearm. After careful consideration and deliberation regarding this motion, and I'm reading this because I want the listeners to understand the way the courts are evaluating medical cannabis usage and the disdain by which many of the courts are taking towards it. This court is not convinced the current bond conditions are against the public policy of the state of Michigan, violate the doctor-patient privilege relationship, prohibit the defendant from making informed consent decisions, nor constitute this court practicing medicine without a license. What the judge was doing there was responding to the 4 major arguments that I had made, which was, by not allowing this to happen, you are violating public policy, you're violating the doctor-patient privilege because these individuals were recommended by their doctor, not you, to take a certain path. They would prohibit the defendants from making their own informed consent and decisions about their medicine, and it would endorse the concept that the court could practice medicine without a license. So they denied my motion for these reasons. The court cannot find any appellate cases or any case from any other state, which is not true because I cited many. Every other of the major states that have medical marijuana do, in fact, have opinions on this, which I cited in my brief. You just chose to ignore them. And most of the cases, he says, relate to terms of probation. He draws that distinction. Therefore, the court believes there's no duty to exercise its discretion based on reason and common sense. Actually said that. Therefore, the court believes that it has no duty to exercise its discretion based on reason and common sense, and can rely on unreasonableness and the lack of common sense, one might say.
Or whatever. And
that no appellate authority is controlling. Reason 2, here you go, my favorite. Federal law prohibits the possession of marijuana and state law does not, provided there is compliance with the MMA. Say what you will about the irony of these 2 laws, but how they affect each other and how they interact, whether or not one will end up trumping the other, seems to me like all these issues have been resolved at this time. I clearly cited Trebeek versus Wyoming. Maybe at the time the Kuhn decision about the trumping, but that doesn't apply to federal law, of course. The bottom line is this court's opinion is that possession of marijuana is still against federal law, and this court does not embrace the position that allowing anyone to violate a law, be it federal, state, tribal, or other. Furthermore, to do so might be contravention of the oath this court took to oath the Constitution, the laws of the United States of America.
That's his only real argument in the whole thing.
But there's
the rest
no.
of it's just blather.
But there's
no argument.
There's no argument because he's not a
federal law at all.
Yeah, there's no federal judge, there's no federal prosecution, and Trebeek clearly resolved that issue by clearly stating that if prosecuted federal law, don't expect to use the Michigan Medical Marijuana Act. But why then would we expect not to be able to use the Michigan Medical Marijuana Act when we're in Michigan? Reason 3: persons who take or use prescription drugs may forfeit the right to use those drugs or give up those use of the drugs, even if temporary, if they misuse or abuse the substance. So he tries to make the metaphor that if someone's abusing it, they can, he has the right to take it away. Although that never happens, and that's just a specious red herring argument. So he denied the motion, and we proceeded to the preliminary exam. But before I get to that, because that's a different path, I do want to say this, that I don't want to give her the story, but we were bound over to circuit court, and we got to circuit court. We had the Honorable Judge Brinkley. And I want to say that I do believe that she will be put on the list at some point as being a friend of the community. I understood her to be a criminal defense lawyer for
Kathleen Brickley.
18 to 20 years. My first pretrial with her in the circuit court led me to believe that she was a judge who was going to follow the law and the will of the people. She actually spoke high regard of another physician who is another doctor that I would say is follows a top-notch protocol, Dr. Crocker, and spoke highly of him and even made some references to how good the big green bud of marijuana looked when others may have been calling it unusable. But nevertheless, she seemed to have some knowledge and understanding of the law, and it had some experiences at the time, and gave me a feeling that she would be open-minded to listening and at the end of the day would follow the law and apply the law to the facts.
It does look good.
But we held our preliminary exam. The preliminary exam involved, amongst other things, challenges to the concept that crime had been committed and probable cause existed that these two individuals committed. And it's worth just perusing and making the arguments. And the same judge that I just read an opinion from regarding medical marijuana also issued an opinion in this case. And by reading it, you'll get a feel for what I argued and how the court made its conclusions. A preliminary exam was conducted on this date. The matter was taken under advisement and reviewed these statutes and the evidence and the case law. Court states what the defendants are charged with, and then goes on to say that these three detectives testified at the preliminary exam that after making an observation of the premises of the grow operation, search warrant was executed. Before the search, the police had noticed on the north side of the residence plants outside that were surrounded by a plastic wrap. Some of the plastic had come loose, and the top of the marijuana plants were observed. There was no roof over the plants. The residency was a single-story wood frame home with cattle gate across the driveway fence in yard around at least 3/4 of the property, though it was never determined about what part of it was not surrounded by the cattle. When the search warrant was executed, both defendants were present and interviewed. At the premises, pistol and shotgun were recovered outside several marijuana plants under a tarp which had no roof, and there was also plants found outside by the slider in the yard that were not closed at all. Testimony was that 112 plants were at the residence. However, the court goes on, each defendant has a medical marijuana card which identifies them as a patient. The wife is also a caregiver for 4 other persons. And the husband is 4 other persons, and the wife is a caregiver to 5 other persons. Understanding that at this preliminary exam, when the burden is on the prosecutor to go forward and establish probable cause of a crime, the crime is being committed and probable cause that my clients committed it, we entered into evidence the cards of my client. The court goes on to say that the court is interpreting the act. Section 4 allows each patient to possess 12 plants for themselves as a caregiver, 12 plants for each other. Therefore, a husband can possess 60 plants, The wife 72 plants, which would be a total of 132 plants, the court finds. There are 112 plants at the residence, and then he comes up with and says, and 83 plants were sent to the lab according to the lab report. So what's very strange about this ruling is that he acknowledges, the court does, that 132 plants could be possessed. He says in the intro that 3 officers testified there's 112 plants. Then he comes up with another 83 plants that were sent to the lab. He goes on to state that the definition of enclosed locked facility is found at 333.26423D and means a closet room or other comparable stationary fully enclosed area equipped with secured locks or other functioning blah, blah, blah. He then goes on to articulate accurately from the amendments as of April 2013, reminding our listeners that the offense date, culpable date allegedly was August of 2012, and judges the evidence based upon the definitions provided for in the amendments of marijuana plants grown outdoors are considered to be, and goes on to cite the amendment. In this case, he goes on in his analysis and conclusion, when the evidence is broken down, the defendants have technical violations of an enclosed locked facility. And reminding, and based upon this technical violation, he's using the amendments, and specifically that maybe possibly from another vantage point, the neighbor's position, the plants could be identified.
But that was not the law.
That was not the law at the time. The marijuana found inside the house did not meet the requirements of the definition. Some of the outside plants weren't enclosed at all, even though there was a question whether they had roots or not. In addition, the plastic surrounding the outside plants on 3 sides was not a chain link fence or wooden slats, although it was misrepresented because the affidavit and the way in which the officers answered the questions of the exam and direct was that the wooden slats were 4 by 4, failing to mention they were 8 feet tall and that they were not, no plants were visible from anywhere. Further, in review of the case law effects, the case defendants are bound over to circuit court. So you get the feeling here of what's taking place. The court, at least, I don't give the court blame here.
They made the decision on the wrong law.
But it took the time to analyze it, which I give it credit for, because a lot of courts don't. They just say blah, 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 blah.
Right.
But anyway, so we get up to circuit court. We had a good experience in the first couple of pretrials. I brought a motion to amend the bond conditions again, and while the relief that I requested initially was to allow patients, clients to use cannabis, I also offered the court an alternative resolution, was to not necessarily authorize it, but just not to test, allowing the patients to use cannabis, not have to report it anywhere. Nobody cares. No one knows about it. The court isn't actually participating in authorizing it and needing to supervise it and know anything about it, but just end it and don't require it.
And they'll do that if they're not looking for any other drugs sometimes.
Correct. And there was no issues of that. The arguments were made. It's a reasonable explanation. I think everything that we argued at the lower court and all the evidence that we brought to the circuit court compelled the judge to a certain degree to go with me to this alternative resolution. And I know we're past my time. I want to wrap this up, but I do want to talk about briefly. We filed 3 motions in the circuit court. We can talk more about this when my client's calling. So we're going to go to break in a second. But the way it went down was this. We filed a motion to quash and suppress the search warrants and affidavit. Filed a motion to quash the bind over of the district court judge, saying that the findings that he had made were an error, and that would be, even assuming all the evidence that was presented in the light most favorable to the people, that still there was a absolute error in the court in using laws of April 2013 and a standard that my clients in the previous year would never have any idea to be or given notice of, that there's violations of due process, notice, and violated the ex post facto law. Additionally, we filed motions, and we had been scheduled a date for evidentiary hearing in Section 8. We had approximately 12 patients lined up to come in and talk about their medical necessity for their needs. And we were all queued up and ready to go. And
Loaded.
there was a number of different points that I wanted to bring up. Maybe I'll get into them. There's some specific things I highlighted in my briefs that I wanted to just read, because what I can only describe is not every attorney gets the opportunity to have the questions to ask and the answers be given that were given in this case. And the cross-examination and the demeanor in which the police officers treated me was in the way they had disdain to the truth and integrity of the system and the following of the law and the ignoring of protections was some of the facts that we used to make our claim that they'd been misleading in their search warrant and affidavit, and they'd omitted facts. And that was like evidence, we argued, as how it supported our claim to entitle us to what we call a Franks hearing. Nevertheless, filed our motions. I was waiting for my prosecutor opponent, formidable opponent, but truly a profession in every aspect of the word, and fought like a devil in court, but was a true gentleman outside, and we got along peachingly, I would say. That's a thing. But nevertheless, got that call from prosecutor that you don't always get. And my joke has been that every time a lawyer's getting ready to go fight a case, they take a look in the mirror, say to themselves, geez, I wish the prosecutor would dismiss the case. They realize they're never going to do it, and they put their suit on and their tie, and they go to court and fight. Get the call. The prosecutor says to me, Komorn, I'm reading your motions, and I am analyzing them, and I got to tell you that I believe that you got me. Like, what do you mean you got me? You got me. And I'm upset at myself because there's some issues here that I should have picked up on earlier. And in analyzing this, what we're going to do is we're going to dismiss all of the charges. And there goes the victory in Paw Paw. We're going to have everyone back on that was part of it to discuss their experience. And we're going to try to extrapolate some more from that. I went way over my time. Then we got Rick Thompson hopefully calling in to give some news. We got our guests lined up, Carrie and Stacy. And you're listening to Planet Green. The call number is 1-347-326-9626.